afternoon, and welcome to today's Pretreatment 101 webcast, Industrial User Permitting. This webcast is sponsored by EPA's Office of Water. I'm Chuck Durham with Tetra Tech, and I'll be leading today's webcast. Thank you for joining us. The National Pretreatment Program regulations identify specific requirements for controlling the wastewater discharges from non-domestic users. When a control mechanism or permit is used to authorize the discharge of wastewater to a publicly owned treatment work, or POTW, it must contain certain conditions and requirements. This webcast provides an overview of the industrial user permitting process and introduces EPA's newly revised Industrial User Permitting Guidance Manual. This is the first of a series of webcasts on non-domestic user permitting. Before our presentations, we'll start by going over a few housekeeping items. Please note that the materials in this webcast have been reviewed by EPA staff for technical accuracy. The mention of any commercial enterprise, product, or publication does not mean that EPA endorses them. First, I'd like to briefly summarize some of the features of today's webcast. If you have any technical difficulties, you can request assistance by entering your technical issue into the box at the bottom of your screen and clicking the Ask button to receive technical support. Responses to technical questions will appear at the bottom of your screen. We encourage you to submit questions to our speakers during this webcast. A question and answer session will follow each of the presentations. To ask a question, simply type in the box at the bottom of your screen. Then click on the Ask button. Given the large number of participants today, I encourage you to submit your questions early. We'll try to answer as many questions as possible. Isheen Lee and Ann Zimmerman of Tetra Tech will be reviewing all of the questions that you submit to us. They'll try to queue up as many questions to our speakers as possible. However, due to the number of participants, not all questions will be answered. We've posted the speaker's contact information in case you would like to contact them after the webcast. We will also be asking you, the audience, general poll and quiz questions throughout the webcast. These questions will be posted in the slide window. Additionally, at the end of the webcast, you will be asked to complete an evaluation survey. Please submit your answers in that same slide window by clicking one of the radio buttons. If you would like to see closed captioning, please make sure that you have turned off your pop-up blocker and click on the closed captioning button on the top of your screen. Please click on the Details and Downloads button to access our speaker's contact information and to download a copy of the slides. There is also a PDF document of additional resources. This document contains a list of commonly used pretreatment acronyms, guidance manuals and documents, and speaker information. We recommend that you download this document. It can be found by clicking on the Downloads button. A certificate of participation will be available for audience members. The certificate button located on top of your screen will be activated after you have watched 90 minutes of this webcast. Furthermore, this webcast will be archived indefinitely so you can access it in a few weeks after today's live presentation. The archived webcast will be posted on EPA's website at www.epa.gov/NPDES/training. Before we start, this slide outlines the 6 minimum pretreatment program elements. These include legal authority, program procedures, funding, local limits, enforcement response plan, and list of industrial users. The Pretreatment 101 series webcast will discuss each of these 6 minimum program elements. During today's webcast, we will be discussing the basics of non-domestic user permitting, which is one of the required program procedures. I would also like to mention that there are several Pretreatment 101 webcasts already archived. These include Introduction to the National Pretreatment Program, Industrial User Waste Survey Procedures, POTW's Procedures for Conducting Compliance Inspections, POTW's Procedures for Conducting Compliance Monitoring, Overview of Pretreatment Standards, and Pretreatment Standards Local Limits Development. Here's a list of common acronyms used throughout the Pretreatment 101 series. For more information about other acronyms used during this and other Pretreatment 101 webcasts, please refer to the Resources document link. By the end of today's webcast, we will have covered all of these topics, so as you see, we have a lot of ground to cover. Please note that during today's webcast, the terms permit and control mechanism are used interchangeably. Before we begin with our presentations, I have a couple of quick poll questions. Have you participated in any of the previous Pretreatment 101 webcasts? Yes or no? While While everyone is voting, I'd like to remind everyone that all the presentations today can be downloaded during the webcast. These presentations are helpful resources for future reference. Thanks for answering that first poll question. Here's another. This question is for those of you who have participated in any of the previous Pretreatment 101 webcasts. How did you access or participate in the previous webcast? A, participated during the live webcast event. B, listened to the archived webcast. Or C, both. Some were live webcast events and others were archived events. Great. Thanks for answering those quick poll questions. Our first speaker today is Ms. Jan Pickrell. Jan will review some pretreatment program background information, describe how to establish a permit program, and outline preliminary permitting decisions. Ms. Pickrell is EPA's National Pretreatment Program Coordinator in the Water Permits Division of the Office of Wastewater Management, otherwise known as OWM. She has been with OWM since 1997. Jan?
Thank you, Chuck. As Chuck stated earlier, this webcast provides an introduction to the development and implementation of a permitting program under the NPDES National Pollutant Discharge Elimination System Pretreatment Program. The publicly owned treatment works, or POTW, or the state pretreatment program must have the authority to deny or condition new or increased contributions of pollutants or changes in the nature of pollutants to the POTW by industrial users, and to control these discharges by permit, order, and similar means. That sentence was loaded with a lot of specialized terms, wasn't it? If they are not familiar to you, I recommend that you listen to our webinar entitled Introduction to the National Pretreatment Program. Also, I encourage you to download the resources document available for this webinar. I know we have a lot of industrial representatives in our audience today. However, because this training is focused on establishing a permitting program, when I use the pronoun you, I most frequently am speaking directly to the permitting or control authority who issues the permit to the industrial authority. To assist you in developing your permitting program and writing permits to industrial users, EPA issued a guidance manual in 1989. It was updated in the year 2012. This manual focuses on the steps required in order for the control authority to comply with the federal pretreatment program. Please contact your state and others in your municipal government for information on additional state and local requirements that might be applicable. Here is a diagram you may remember from the webinar, Introduction to the National Pretreatment Program. To refresh your memory, this diagram generally displays locations where violations of pretreatment program standards and requirements might occur. The POTW establishing its pretreatment program needs to determine how it is going to protect its collection system, its piping, its treatment plant, and also ensure compliance with its own permits. In addition to specifying some minimum legal requirements for POTWs to have available in its toolbox for implementing a pretreatment program, the federal pretreatment program also specifies some minimum activities that a POTW must conduct. The POTW must develop procedures to carry out these activities in a systematic and non-arbitrary manner. One of these is issuing permits. Looking at this diagram, the POTW Control Authority could logically issue a permit to an industrial user with conditions to prevent harm to the piping or collection system, such as ways to prevent blockages from occurring and to prevent corrosion, explosion, or emitting toxic gases. Similarly, the POTW Control Authority might issue a permit to protect the POTW plant operations and treatment capability. The POTW might identify a maximum amount of a certain pollutant that the industry can discharge. This amount could be set so that the POTW plant can still function properly and not discharge the pollutant untreated. How those pollutants are allocated between each of the users and how reports are to be submitted by those users to the control authority are decided at the local level. So what is a control mechanism or permit? EPA uses the phrase control mechanism as a generic term that includes permits. For this presentation, we're going to use the terms control mechanism and permit interchangeably. We are referring to that legally enforceable document that is issued by the Pretreatment Program Control Authority to an individual industrial user doing business at a particular location. The permit is a single reference document that tells that company what it needs to do in order to continue to have permission from the municipality to discharge its wastewater. If that industry does not meet those conditions, that privilege to discharge may be taken away. In addition, the industrial user may be subject to penalties or fines for violating those conditions. The industrial user would also be expected to pay for any damages caused by a violation. Okay, guys, let's admit it. We're learning about industrial user permits because the regulations require POTW state pretreatment program control authorities to issue them. The control authority must have the legal authority to deny or condition new or increased contributions of pollutants to the POTW by industrial users. And that means all industrial users, all of the non-domestic dischargers. However, the regulations further specify that permits must be issued to those users that are classified as significant industrial users. We'll define what that term means a little further in today's presentation. Because the permit serves as an enforceable legal document that identifies duties and responsibilities to the industrial user, it specifically serves as a tool to notify the industrial user of the standards and requirements that are applicable to it and its discharge. When setting up its permitting program, the control authority should work with its municipal or sewer authority attorney to ensure that its legal authority and actions meet the federal, state, and local requirements. The specific components that must be included in those permits issued to the SIUs are included on this slide. We'll discuss what each of these mean in greater detail later in the presentation. Some of these components might be the same for all users. Some of these items might be different for each of the users. It's the duty of the Pretreatment Program Control Authority to consider each of these components and what it means to each individual user. The permit needs to be properly worded, legal, and justifiable. The permit needs to be issued in a manner so that it's enforceable, so that a violator of any of the conditions can be made to correct a situation if a harmful situation arises. A permit is considered to be an adequate control mechanism. However, a contract is not. The differences between a contract and a permit and why a contract is not an acceptable control mechanism are discussed at length in a 1988 Federal Register notice that is cited at the bottom of this slide. The differences really boil down to issues involving contract law. Contracts are mutual agreements between two parties where both parties have responsibilities. A violation of a contract is considered a breach of contract, and only charges that are pre-identified in the contract may be assessed for a violation. It'd be very difficult to predetermine what unknown damages to a publicly owned treatment works might cost to repair. That's one of the reasons why contracts are not valid for the purposes of a pretreatment control mechanism. Other reasons are outlined in the slide, and again, if you want more details, please consult your local attorney and the summary in the Federal Register notice. So who issues permits? The control authority has direct oversight of the industrial users. Because the POTWs have the most vested interest in protecting their plant, we call them the control authority after their program has been established and approved as satisfying all the minimum federal requirements. The approval authority has oversight of the control authorities. Most typically, the approval authority is the state which issues the NPDES permit to the POTW. But in some states, EPA still does this task. Where a POTW does not have an approved pretreatment program, the oversight of the industrial user falls back to the approval authority, meaning the state or EPA. We nickname those states that have an approved pretreatment program as being delegated states, and of course those that don't have a program, non-delegated states. Then we also have some states that have an approved pretreatment program but tend to issue the permits themselves, and we call those the 40310E states after that portion of the regulations. So here's a visual to show you in color which states have the NPDES program authority, which states have the pretreatment program, and both. On that website that's listed there on the slide, you can find out when those states were approved for the various components of the NPDES program. As of the year 2012, there are 36 states that have approved state pretreatment program authority. So that means that if you're located in one of those other 14 states, you don't have a state pretreatment approval authority. You have to talk directly to the Federal Environmental Protection Agency. Here's another way to help you think about those terms about who is responsible for issuing industrial users permits and who does the program oversight. As said before, most typically the POTW program, acting as a control authority, issues the permit directly to the industrial user. If you are an industry, this slide shows you that the first entity that you, the industry, should contact with questions about what you must do in order to discharge to the local sewer authority is to contact the local sewer authority POTW. They are most likely your control authority. There are many types of non-domestic users for the POTW to think about when developing its procedures. Significant industrial users, categorical industrial users, all of the rest of the industrial users, waste haulers. Do you have authority to accept wastewater from all of the above or only some of the above? Where does that POTW start? We'll go into more detail about this. But yes, SIUs in cities with approved pretreatment programs are required to be permitted. And beyond that, remember that the federal regulations require that a pretreatment control authority be able to deny and condition and control through a permit any industrial discharger. Let's focus just on the SIUs right now, and you'll discover how you can impose controls on smaller users later. So far, we defined in general concept of what a pretreatment permit is, who issues it, and who oversees whom doing that process, and briefly touched on who receives that permit. Let's look again at your list of who the control authority must issue a permit to, and then who you might issue permits to. When setting up your permitting program, the federal regulations at 40 CFR 403.8F13 specify that the POTW must control through permit, order, or similar means the contribution to the POTW by each industrial user. The regulation also identifies individual permits and general permits. Perhaps when you're looking at all of your industrial users, you as a control authority can look at them and look at the different characteristics each might have. Might it look like you're issuing nearly the same requirements to multiple users? Keep this idea in mind, and we'll talk about that more when discussing general permits. If knowing that the regulations require control authorities to issue permits or control mechanisms isn't enough for you, why issue permits? Think of the permit issuance as a process to control your treatment works system. Your municipal treatment works is a conglomeration of steel and concrete to which you might add chemicals, but most treatment works are also living and breathing organisms, relying on bacteria to function properly. Your success at keeping the treatment works alive requires you, the pretreatment program manager, to think and use your judgment to figure out the best ways to keep track of what types of wastewater is coming into your treatment plant and how to best control that wastewater coming in so that you can balance that breathing organism with chemicals you might add. When developing a tracking system, use the administrative process to keep your bosses involved, the public involved, the industry involved, so that there can be the proverbial win-win situation of everyone knowing why they are doing these things. The permit itself should help that by putting it all in writing. So, Chuck, help me out here. Is it time for a quiz?
Okay, thanks, Jan. That was a brief overview of control mechanisms and permits. So before we continue with the rest of Jan's presentation, here's a quick quiz question for everyone in the audience. This is a multiple choice question. Control mechanisms can be issued to A, industrial users, B, significant industrial users, C, categorical industrial users, D, none of the above, or E, all of the above. To answer this question, please use the radio buttons to the left of your choice and click Submit. Do not type in your answers in the Ask a Question box. While we give everyone a chance to answer, a reminder, if you have any questions for our speakers today, you can submit these questions at any time during the webcast. Please type in your questions in the Ask a Question box. We will try to answer as many of your questions as possible. It looks like everyone has had a chance to answer. The correct answer is E. Control mechanisms can be issued to industrial users, significant industrial users, and categorical industrial users. Now let's continue with Jan's presentation. Jan?
Okay, in this section of the webinar, we will discuss some activities that a pretreatment program will perform before it begins to issue permits to its industrial users. Logically, it first needs to find out who they are, where they are, and what they are discharging. When the POTW Control Authority may be able to prioritize its industrial users that need to be addressed first. For an in-depth discussion on how to identify industrial users, please consider viewing the Pretreatment 101 webinar titled Industrial User Waste Survey Procedures. Be aware that existing users might be the first step that a POTW takes in order to bring its non-compliant effluent quality back into compliance. The POTW NPDES permit may require the POTW Control Authority to periodically submit a list of its industrial users discharging to its system. In addition, identification of those users is a requirement of an NPDES permit application for POTWs. Maintaining such a list is also a required pretreatment program element. The POTW should work with and use resources available from all of its municipal offices in order to compile this list: the billing department, business license department, plumbing inspectors, and so on. Both the POTW pretreatment permit writer and the inspector need to constantly be aware of changes: new industries that move to town, industries that close, industries that change their processes, add new process lines, close process lines, change their chemicals. The POTW Control Authority needs to develop procedures so that it can find out about such developments before they happen. This is because each of these changes may result in changes in the chemistry of what's coming down the collection system line and into the POTW treatment plant. The pretreatment program goal is to deal with these things on a proactive basis and not on a reactive basis to the extent possible. In addition, these changes may change when federal pretreatment standards and requirements are appropriately applied and change the limits that are imposed on the discharge. And these are limits the Control Authority would place in that industrial permit. Consequently, the POTW Control Authority will need to decide how it will gather up this information that it uses in order to make informed decisions. Before the quiz, we discussed that the POTW Control Authority must be able to control discharges from all of its non-domestic users. Any non-domestic user is considered to be an industrial user. Non-domestic users include both commercial dischargers and the traditionally recognized industrial discharges, as the federal regulations do not distinguish between these two types of industrial users. Now we're going to define what it means to be an SIU, significant industrial user, to whom the pretreatment permits must be issued by the Control Authority, as well as we'll discuss a CIU, or categorical industrial user. When prioritizing which IUs that POTW Control Authority must issue permits to, the POTW needs to be able to identify which industries fall into these categories. EPA has defined significant industrial user as the following. First off, you have categorical industrial users. For these industries, EPA has evaluated several industry sector processes and their wastewater and available treatment technologies in order to determine federal discharge standards for that industry sector. By default, if you find you have an industrial discharger discharging to your system that is subject to these regulations, consider them to be a significant industrial user until otherwise determined. Next, we have industries that discharge greater or equal to 25,000 gallons per day of processed wastewater, contributes 5 or more % of the hydraulic or organic loading of the POTW, or has the potential to adversely impact the POTW. Categorical industrial users, as I said before, by default are considered significant. However, some states and some municipalities out there have adopted a provision that allows some of the categorical industrial users to be considered non-significant. You need to check with your state or your municipality to see if this option is available. You can see on this slide what the qualifiers are. They have to be very small discharges, less than 100 gallons per day, and have a compliance history that says they have been consistently in compliance with all applicable categorical pretreatment standards. They also must never discharge any untreated concentrated wastewater to the POTW. There are also some categories or some groups of the categorical industrial users that actually have a limit that says no discharge. And so you need to be aware of those too. Now here is a list of some, not all of, the categorical pretreatment standards. You can find these regulations at 40 CFR 405 through 471. On that EPA website that's listed there, you can sort through the list of industries and download regulations as well as some specific guidance documents pertinent to that industry sector. When categorizing its significant industrial users, the POTW needs to consider several factors. Up until now, we've mostly been discussing terms and the who does what in the pretreatment program. Then we discussed the need for control authority to identify all of its industrial users and how to classify them so that the industrial users can be prioritized for issuing permits. How permit issuance is only one activity in a long list of activities for the control authority to develop procedures for. Permits might be modified, terminated, due to an industry changing or closing. An owner might sell its facility. A new owner might buy it and want the conditions of the old permit transferred to it. Because this program is established to protect the publicly owned treatment works, the public is a stakeholder and they deserve the opportunity to participate in decision-making process that may affect the rates that they pay or even the collection system that runs in front of their homes. Last but not least, a permittee may object to conditions in the permit issued to it and may want to appeal the permit and get a new and different one. That's another activity that the control authority might do. Here is a flow diagram that shows the typical steps that a permitting staff may perform when navigating the permit through its permitting process. It can be found in the 2012 Industrial User Permitting Guidance Manual. When must permits be issued? Okay, first consideration. We talked about identifying and classifying the industrial users for permitting prioritization. So where do we start? Well, of course, the minute that your pretreatment program is approved by the state or EPA, you, the control authority, can issue all of those permits to your existing significant industrial users right away, right? You probably have already queued them up for issuing while you were waiting for the approval process to complete, right? Now, to protect your collection system and POTW treatment plant, you should realistically issue the permits as soon as you can because they inform those industries of actions they need to take so that the collection system and plant are protected. So what about the new sources? You want to be able to see some characterization of what they discharge or anticipate to discharge before they connect and discharge so that you can evaluate if you can even accept those pollutants. Consequently, you want to issue those conditions before that discharge occurs. As a matter of daily workload considerations and the number of permits you might be issuing at a given time, you should evaluate if it makes sense for you to issue all of the industrial user permits at the same time or stagger them throughout the year. In between a permit cycle, the industry may want to change its operations for various reasons. An increase in production, perhaps? In addition, the POTW might have a new limit on its discharge for which it knows a certain industry contributes that pollutant, and thus it will need to control that pollutant coming from the industry contributing it. For many reasons, the POTW Control Authority needs to make sure that it has the legal authority to change a permit before its expiration date. This authority may be expressly stated in the municipal code as well as in the permit. The control authority should anticipate changes like this will occur, and something always does. And so therefore the control authority needs to develop a procedure to identify how it responds to such requests and needs. Does it use the same procedure that it uses when it does the permit issuance? How frequently will the control authority reasonably modify a permit? How will the control authority identify the changes in the permit itself? Documentation is clearly the key so that the permit does not become a confusing tangle of different limits with different dates and uncertainty of why a change was even made. Another permitting action is that possibly an industry may discontinue performing an operation and that discharge permit is no longer needed. Or possibly that discharger has a long history of noncompliance and the privilege is being taken away from that industry to discharge. Both of these situations could result in a permit termination. Of course, both of these might get vastly different reactions from the industrial user, but both might be logically expected in the normal course of business. The control authority should coordinate with its attorney to ensure that both activities are performed in a legal manner. Another situation that may also be viewed as a permit modification, but might also be considered a termination, is when there is an ownership change. The federal regulations are specific in that the permits are not a commodity to be sold or traded, but if prior notification is made and the new owner demonstrates or certifies that exactly the same operation will be performed, the new permit might look exactly like the old one, just with a new name. Or the control authority might just decide it's easiest enough to just terminate the old permit and issue a new permit to the new owner. You might say that all of those actions that we discussed have been administrative procedures. Yes, and many municipal governments have requirements that specify procedures already for them. When setting up your pretreatment program, make sure that you incorporate and comply with your state and local requirements. So let's talk specifically about the permit again. For what period of time do you issue an industrial user permit? How long is it in effect? The federal regulations specify that the maximum length of time is 5 years for SIUs. Not 5 years and 1 day, not 8 years or 10 years. However, at a local level, a POTW control authority is certainly allowed to, and I've seen very many instances where they take the policy to issue permits of only 1 or 2 years duration for the new dischargers, until they can be assured that the new industrial process works or the new treatment system works. As long as the POTW control authority has the legal authority to do so, the procedures to demonstrate that such decisions are not arbitrary and capricious, the POTW is able to do this. EPA and state NPDES permit authorities have specific procedures for making new and modified permits and new and modified pretreatment programs available to the public and other interested parties. However, the federal regulations are silent as to if the POTW control authority must allow public authority comment in the issuance of each SIU permit. Nevertheless, the control authority should develop procedures to respond to public inquiries. Common activities could be public noticing a draft permit on a website or newsletter, or holding public meetings. The control authority needs to investigate and incorporate whatever state or local public participation requirements are pertinent. Permit development itself should be considered a collaborative process, involving open communication between the control authority and other municipal officials who may deal with the industry on related matters. Allowing the industrial user to review a draft permit might ensure that incorrect assumptions by either party are not carried forward into the final permit and need to be corrected expeditiously. Such communication also allows the control authority and industrial users to discuss terms and reasoning behind certain requirements, sometimes even resulting in an industry altering a chemical use because it discovered that its process was ineffective, but the chemical could then allow better handling at the POTW. After the public participation requirements, if any, are satisfied, the control authority revises the draft permit as necessary and proceeds to issue the final permit to the industrial user. A transmittal letter may accompany the permit to the industrial user, and it might summarize the contents or highlight changes from the previous permit. In order to make sure that the industry has received the permit, some control authorities hand-deliver the permit. Some have the letter mailed by certified mail return receipt. If you do that, make sure you receive a signature saying when the industrial user received that permit. Once the final permit is issued, industrial users should have the right to challenge or appeal specific provisions in the permit that they believe are contrary to law or unreasonable exercise the control authority's discretion under that law. The control authority might consider establishing within its legal authority an administrative forum where interested parties can request consideration of specific conditions. Such an administrative appeal process may allow for legitimate errors to be corrected without expending the resource requirements at a judicial proceeding. The request for reconsideration should not result in an automatic stay of the final permit conditions. However, if a request is granted, a stay might be considered appropriate at the discretion of a board member or director. As alluded to earlier, while the control authority is compiling its list of existing industrial users and their characteristics, it might discover that there are several industrial users that conduct the same processes and might be subject to the same standards and requirements. If so, the control authority might want to investigate the use of a general control mechanism or general permit. If these general permits are used to regulate significant industrial users, they must contain the federal minimum requirements. However, POTWs might save time by crafting only one permit that is issued to several industries, instead of perhaps several permits that all look nearly identical except for the name on the top. It's an economy of scale type of situation. As a caution, again, make sure that your state or the POTW code allows the issuance of such general permits. There are situations when general control mechanisms cannot be issued, and such are typically when any calculations must be performed in order to specify what the specific limitation would be in that permit. So where would you consider using a general permit? The POTW permitting staff would be on the lookout for when it has multiple facilities with the same or substantially similar types of operations, discharge waste with the same characteristics, and then the POTW would be imposing the same limits and monitoring requirements. Notice in this side that the word same seems to be repeated there. That should be a clue to you. The POTW may have additional qualifiers for allowing an industry to obtain a general permit and may actually have additional reasons for not allowing a general permit. Before issuing the permit, again, make sure that the control authority has legal authority to use this tool, because not all control authorities do. As this webinar is designed to make control authorities aware of factors to consider when setting up its pretreatment program, the control authority should also decide if and how it might issue general permits issued to significant industrial users any differently from individual permits issued to significant industrial users. The control authority should consider if it wants to or needs to develop general permits for other classes of industrial users, such as restaurants or car washes. Some typical procedures that are different from individual permits include publicizing the availability of the general permit and how an industry might apply for the general permit. The control authority needs to consider how it determines an industry qualifies for the permit and when that industry might not. Also, the control authority needs to maintain records of why those particular industries did qualify and why those others did not. Organizing sampling data and records for multiple users under the same permit might also be a bit different than how the control authority keeps records for an individual permit files.
Okay, Jan, let's ask the audience members one more question before we get back to your presentation. This is another multiple choice question. This question deals with permit durations. An SIU permit may be issued for A, 1 year, B, 5 years, C, 7 years, D, A and B, E, A and C, or F, B and C. Remember, when answering any of these questions, please use the radio buttons to the left of your choice and click Submit. Do not type your answers in the Ask a Question box. Thanks for answering that quick quiz question. The answer is D. SIU permits can be issued for up to 5 years. Therefore, A and B are both acceptable. I believe Jan has a couple of more slides in her presentation. Jan?
Okay, I'll try to quickly wrap some of this up. We are now going to get into talking about specifically writing the permit. We'll be focusing on typical practices for writing and issuing permits for significant industrial users, because these permits are those for which the federal regulations are prescribed. So what information needs to be collected when issuing a permit? The control authority must gather information about the industrial user, its processes, what chemicals are used, where they are stored, what pollutants are present in the wastewater, so many things. But a bunch of this is common sense, right? Knowing that information is how the permitting authority figures out what conditions to include in a permit. Make sure that you have the legal authority to request information directly from the industrial user. Information relating to how to determine limits, such as production rates, are not considered confidential business information because this information is necessary in order to calculate permit limits. We'll talk about that situation later. Knowing what information the permit writer needs to write a permit, the permit writer then gathers it all together so that he or she can specifically review it and be assured that he or she is developing a permit based on sound information. The federal pretreatment regulations do not specifically require a permit application to be used. However, there is a special classification of industries called categorical industrial users, CIUs, that must submit a baseline monitoring report that looks an awful lot like a permit application if you really get down to it. And we do discuss baseline monitoring reports, or BMRs, in more detail in the Pretreatment 101 webinar, Overview of Pretreatment Standards. But considering that it looks awfully permit application-like, many control authorities do use these requirements as an outline for developing a permit application. It asks such information of how much water is generated, what processes are used to generate that water, what sampling data is available, what volume of water is used or discharged, what types of chemicals are used. Remember that permits are only effective for a maximum of 5 years, so you'll want to think about how you're going to get updates of that information so that you're prepared when any changes occur. Also, you need to be ready for that next round of permits 5 years later. Do you ask for additional information using an application form, or do you gather it during an inspection? I'm just brainstorming some ideas for you. Appendix C of the Industrial User Permitting Manual contains an example permit application. Let's say that you use an application form. Did the potential permittee fill in all of the blanks? If not, why not? Hopefully, you have a question on the form, and you can look at it to easily see when it's been not filled in and when it has been filled in. It's possible that the applicant skipped a question knowing that he would get back to it to fill it out once it got the information out of its own file, but then forgot to fill it in. Or perhaps they wanted to ask you a question about what it meant and then forgot. So review that application to make sure it is filled in completely and why it might not be. As you gathered the information and are looking at all of the data that's on that form, check it for accuracy. Is there a logical reason why numbers in one form compared to perhaps your inspection form conflict? Are they different for different reasons? It's possible there could be different production rates during different processing seasons. Or is that particular indice showing a trend in production rates, increasing production or decreasing production? You should check that application to ensure that it's logically accurate in mathematical areas, as well as note where it might have changed since the last permit that was issued. Find out why there are differences and make sure that the correct information is noted. Be curious. Be an informed permit writer. Besides checking for completeness and accuracy, which are, of course, administrative tasks, you'll want to also review the information submitted to ensure that you know which are the correct standards and requirements to apply. Make sure that there's enough information gathered to support a determination that these standards are appropriate. For example, for that categorical industrial user, what process are they doing and when did they begin the process? All of these things affect making sure that you have the correct set of standards that you are applying to that permit.
Thank you, Jan, for discussing the permit program. The preliminary decision is needed for issuing a permit as well as the permit writing procedures. While we sort out all of the questions, let's take a moment to ask the audience to answer a poll question. How many people are participating at your location today? A, just me. B, 2 to 5. C, 6 to 10. D, 10 to 20. E, more than 20. While we're waiting for everyone to answer, I'd like to remind the audience there's a resources document available for downloading. This document contains a variety of useful resources. I would also like to remind everyone that there are several archived Pretreatment 101 webcasts that can be found at www.epa.gov/NPDES/training. Please visit that site for more information. Before we introduce our next speaker, here's another poll question. Oh, I'm sorry. Let's go to some questions. While everyone is answering the poll question, let's see if we can have questions from our audience members. Isheen.
Thanks, Chuck. We do have some questions for Jan. Actually, we have a lot of questions. So let me queue one up for you, Jan. Let's see. Are SIUs required to resubmit permit applications for each permit renewal?
Well, actually, the federal regulations do not specify an application. A local municipality might use an application form. A state might use an application form. It's really up to the local control authority on if they are using specific permit applications.
Great. I hope that answered your question, audience member. Here's another one. Someone wants to know if a control authority can issue permits that are less than 5-year durations.
Well, 5 years is the maximum that the federal regulations allow an industrial user permit to be issued. However, local control authorities and states are allowed to issue permits of a shorter duration. What you might really need to ask is, do you have the authority to issue shorter permits? There might be reasons why you might want to issue shorter permits. For example, if the industry is going through lots of changes, as well as if the industry is just starting up and you want to make sure that you have a good steady state of information to show that the treatment process is actually operating efficiently and can meet the standards?
Okay, good questions from the audience there. Before we go on with the presentations, here's one more poll question for the audience. What kind of entity are you? A POTW or local government. B, EPA or state personnel. C, industry or industrial facility. D, academic institution. E, a consultant or contractor. Or F, other. Thank you, audience members, for answering our questions. Let's continue with our presentations. Okay, for our second speaker today, we have Grace Scott, who will discuss the components of a permit. As Michigan's pretreatment coordinator, she performs pretreatment audits, industrial inspections, local limit reviews, and provides compliance assistance. Ms. Scott has been employed by the state of Michigan in its water programs for 28 years and has been involved with pretreatment since 1990. Grace?
Thank you, Chuck. Thank you today for the opportunity to speak to you about industrial permitting. The state of Michigan has implemented the industrial pretreatment program since 1983. In Michigan, the state does not issue industrial user permits. Industrial user permits are issued by the local control authorities. It is an important aspect of a program, probably second to the sewer use ordinance. Today I will be describing permit contents. The contents of a permit include the cover page, effluent limits, monitoring and reporting requirements, standard conditions, and possibly special conditions. Depending on the complexity of a permit, it can get pretty lengthy. Therefore, it is recommended that you put the most important information in the first few pages. The cover page of the permit should have the appearance of a legal document. EPA recommends that the cover page be printed on official agency letterhead or stationery. Even using an 8.5 by 14 paper gives the appearance of a legal document. The cover page should contain the name and address of the permittee. Make sure that the legal name of the permittee and the facility's physical location appear on the cover page. You may also want to include the mailing address if different. A citation of the legal authority that the control authority uses to issue the permit, duty to comply, reapplication requirements. Normally the reapplication is required 180 days before the permit expiration, but it may be shorter. The effective period should be clearly defined, and if it is different than the date that it's issued, it should be indicated, and it should be clear that the term is 5 years or less. Sometimes I've seen permits where they issue it on January 1st and add 5, and then it ends up being taken all the way to the end of the next year, which makes it 6 years instead of 5. The signature of the control authority should be clearly defined, and only the signature of the control authority should be on the cover page. You should not have the permittee sign the cover page. That could be interpreted as a permit. As a contract rather than a permit. An important part of the permit is the list of effluent limits that the IU must comply with. Prior to applying any effluent limits, the permit writer must first identify pollutants of concern that need to be regulated. The permit writer must consider whether the industrial user is subject to categorical pretreatment standards and the pollutants that are present or may be present in the wastewater. When a determination can be made as to what pollutants to regulate and the monitoring frequency. Of course, specific permit limits must be included in the permit for all pollutants regulated by any applicable federal categorical pretreatment standard, as well as local limits. The control authority determines what local limits need to be monitored in addition to any pollutants regulated by federal categorical standards. A permit is required to have all applicable effluent limits. Therefore, a user would also be subject to national prohibited discharges. Any applicable local limits and even possibly site-specific limits, such as a prohibition against the discharge of perchloroethylene for dry cleaners, or a requirement to install an amalgam separator for a dental practice. This presentation only provides a general overview and explanation of categorical determination. If anyone would like a more detailed examination of a category in your particular area, please indicate that during the survey at the end of this broadcast, or contact your state or EPA representative. A list of contacts may be found on the Effluent Guidelines website. I would contact your local municipality first if you are a permittee. Many guidance and development documents exist to help with these determinations. In addition, the federal registers that publish the draft and final versions of the Effluent Guidelines are a valuable resource. When applying the categorical pretreatment standards, the control authority must first determine the correct category. Once the category is determined, you must determine which subpart and what time period the category actually started, and determine if they're a new source or existing source. EPA has created a memo which lists the new source dates, and that's a valuable resource to use. Without it, I wouldn't be able to figure out some of the dates, since some of the subcategories are different even between one particular category. When identifying all the waste streams, the control authority should clearly designate each waste stream as either regulated, unregulated, or dilute. This will be important when applying the combined waste stream formula, which will be discussed in a different webcast. When identifying sampling locations, remember that categorical standards are applied directly to the specific waste stream at the end of treatment, or otherwise known as the end of process. Another sampling point could be end of pipe or property line manhole, which is the point of discharge that the public user, that the discharger discharges into the public system. The control authority should keep in mind that when the designated sampling location described in the permit contains a categorically regulated waste stream, that one or more other unregulated waste streams that are combined, that another sampling point may be more appropriate, such as one at the end of the regulated waste stream, which could only capture regulated waste. When you start commingling waste, it makes the permits much more difficult, and you have to have a lot more information in order to determine the proper standards. If the effluent limits have both daily and maximum monthly or daily, the category and the local limits must be compared, and the most stringent must be used. The control authority can also consider the option of converting production-based standards or the standards can be converted from concentration to mass standards, and that was part of the streamlining. So you have to make sure that the regulations in your area allow you to do that. If the control authority has classified a user as a CIU, the control authority is reminded that the categorical standards can be concentration-based, production-based, or can be based on a BMP. Concentration-based limits are the most common type of categorical limits and are the easiest to implement. Production-based standards require much more information and are normally expressed in terms of allowable pollutant mass per unit of production. BMPs, or pollutant management plans, are plans that the user develops that states the facility will conduct its operations in accordance with certain federal requirements. For example, in the transportation equipment cleaning category, there's an option for a pollutant management plan. Those plans are used in lieu of compliance with a set of standards and describes activities that the user will do to prevent pollutants from entering the waste stream. Categorical standards can also specify prohibited discharges, such as those in the steam electric category, which prohibit the discharge of PCBs. The optional methods for applying categorical standards include equivalent mass limits, equivalent concentration, pollutants not present, or non-significant categorical users. These methods were part of the streamlining regulations that were put into place in October of 2005. Before the control authority can implement any of these options, first it must be in your legal authority and allowed under your state law. Equivalent mass limits for concentration limits. To be eligible, the IU must comply with 40 CFR 403.6 C5 I, A through E. The permit must include the requirements listed at 40 CFR 403.6 C5 2 A through D, and the control authority must convert the equivalent mass limits by using actual daily flow rates and reassess the equivalent mass limit when necessary. There is a rather detailed process to verify water conservation practices and proper pretreatment, and verify that the proper pretreatment is in place. And this is described more fully in the regulations. This will be discussed further in future webcasts. The equivalent concentration limits for mass limits are applicable for the following categories: the organic chemicals, plastics, and synthetic fibers, petroleum refining, and pesticide chemicals. The control authority can also convert categorical mass limits into concentration limits. The next slide demonstrates when it might be appropriate to convert the mass to a concentration. The control authority may have the authority to establish equivalent mass limits or equivalent concentrations for federally established concentration-based and mass limits. The control authority may also want to establish some flexibility when applying its local limits. There are some circumstances when converting concentration limits to mass limits or converting mass limits to concentrations would be appropriate. The provision for pollutants not expected to be present is something that was added under streamlining as well. It allows a user to forego monitoring for a pollutant that is listed in the federal category. Where the program has included this provision, the control authority has the option to authorize a CIU to forego sampling of a pollutant if the user can demonstrate through sampling and a technical evaluation of the facility's operation that a given pollutant is neither present nor expected to be present in the discharge, or only present at background levels. That doesn't mean that the user can use this provision if they never found a detectable amount. It depends on if the pollutant has a reasonable potential to be present in the discharge. Even after the control authority has granted a monitoring waiver, a pollutant not expected to be present can be monitored if the control authority requires it to be. And if any time the pollutant shows up in the sampling, or the user becomes aware and reports that it is present, then they have to resume sampling. And if there's any monitoring that takes place where there's a violation, the user would still be found to be in violation of the categorical standard. Also, this can only be used for pollutants that are monitored. It does not supersede the categorical certifications that are required. The monitoring waiver is only available for the duration of the permit. The user must provide sampling data of processed waste streams prior to treatment. So it's really a lot of work to demonstrate that your internal waste streams do not include the pollutants of concern. And waiver requests must be signed in accordance with 403.12L, and conditions of the waiver must be included in the permit. Monitoring, like I said, monitoring must resume if the conditions change. Non-significant CIUs, I really expect that there's very few. We've only identified about 6 that could possibly qualify in the state of Michigan. However, we do not have this in our rules and do not allow non-significant CIUs not to be permitted. Because non-significant CIUs are no longer considered significant industrial users, there's no federal requirement to control these users through a permit or any other control mechanism. The control authority, however, at its own discretion, may issue a permit. I've seen a number of permits where a control authority has issued a permit which indicates that you shall not discharge this categorical waste without notification and a requirement to comply with the regulations. National prohibited discharges are identified in 403.5A1. A user may not introduce into a POTW any pollutants that cause pass-through or interference. The specific prohibitions also further define what a user cannot discharge. And also, this would include users that aren't under a pretreatment program. They cannot discharge things that would cause fire, explosion, corrosion, specifically corrosion that's caused by a pH of less than 5, unless the system is specifically designed to accommodate lower pHs, solid or viscous materials that can cause problems or block a sewer, pollutants that cause interference, BOD often is something that is seen at a high level, which can cause problems if discharged in a slug. Heat, petroleum and mineral oils, toxic fumes and gases that can cause acute worker health and safety problems, or truck waste unless it's specifically at a designated point. And normally that's a point within the gate of the wastewater treatment plant so they can keep track of the waste that's coming in. EPA recommends that the provisions be included by direct inclusion of verbatim language from the sewer use ordinance. The language may be inserted either in the effluent limits section or in the standard conditions section of the permit. Section 403.5C of the General Pretreatment Regulations requires control authorities to develop and enforce specific limits to implement the general prohibitions against pass-through interference and the specific prohibitions. In July 2004, EPA established an extensive guidance on developing and implementing local limits. For the purposes of this webcast, it is assumed that the control authority already has developed technically based local limits. The permit must include a list of all applicable limits, even if the control authority is not requiring the industrial user to monitor for all or any of the pollutants within the local limits. This approach ensures that the industrial user is aware of all local limits. Remember that local limits are typically developed for end-of-pipe compliance. It is important that the permit writer clearly and correctly apply the effluent limits in the permit. The permit should clearly designate the sampling point where the limits apply, the period in which the limits apply, and the units. In addition, the effluent limit should be expressed in terms of the duration for which the limits themselves are intended. There are many different ways that a control authority can implement their limits. They can implement them as instantaneous maximums, maximum daily, maximum average, and in some of the categorical limits, you'll even see things like a 4-day average. And these should be well defined in your ordinance and even in your permit so that there's no question as to what is meant when you say what a monthly average is. This slide demonstrates where the various sampling locations should take place to show compliance with the various standards. Local limits or use of the combined waste stream formula can be used at sample point 3. The sample point 1 indicates the sample prior to the combined metals treatment where cyanide destruction has taken place, and that's an alternate site that can be used to monitor for those users that have cyanide. Sample point 2 is where the categorical industrial regulations apply. A permit can contain a mixture of categorical pretreatment standards and local limits. Often it's easier for a categorical user to be monitored at both the end of process and then at the local limit sample point 3 for those pollutants that are of concern at the local level, rather than trying to apply the combined waste stream formula. This table demonstrates how to apply the most stringent daily maximum limit. And the daily maximum may be different depending on what pollutant you are looking at. So make sure that you review the categorical standards and the local limits and pick the most stringent.
Okay, before we continue with Grace's presentation, let's take a quick quiz question. The next question's in a true or false format. True or false, the control authority can establish more than one sampling location in a CIU's permit. Okay. While you're answering that, we've noticed that we're receiving some questions for Grace already, and some of the questions that have been submitted are beyond the scope of this webcast. Please note that specific questions regarding production-based limits and combined waste stream formula calculations will not be answered during this webcast. EPA is currently developing a webcast to discuss these topics, so please keep that in mind when you're submitting your questions for Grace. Now, the answer to our quiz question. The answer is true. The control authority can establish more than one sampling location in a CIU's permit. One instance when a control authority may want to establish more than one sampling location is when a CIU has multiple categorical processes, and each respective categorical process has its own treatment. The control authority can decide to establish multiple end-of-process or end-of-treatment sampling points. Another instance could be the control authority would need to establish both an end-of-process or end-of-treatment sampling location to evaluate compliance with categorical standards, and an end-of-pipe location to evaluate compliance with local standards. Before we go on to Grace's presentation, I wanted to share some information with you regarding attendance. We have 1,344 attendees registered today, covering 44 states and 4 countries. So we appreciate your participation. Okay, now let's continue with Ms. Scott's presentation. Grace?
Thank you, Chuck. Monitoring and reporting. The monitoring and reporting is an important aspect of a permit, and it should be clearly spelled out in the permit document. The sampling locations, now there can be more than one sampling location, as we talked about earlier. The pollutants to be monitored, including pollutants with a sampling waiver, sampling collection methods, whether it's a grab or a composite or a flow proportioned composite, the analytical methods, and that's very important because recently there were changes to Part 136, and the correct analytical methods must be described in the permit, at least as far as a reference to 136. In some cases, there may be a need to have the actual analytical method. For instance, with mercury, if you want them to use a lower level mercury as opposed to 245.1, you'll have to have 1631 in the permit. But for most cases, reference to 136 is adequate. In addition, you'll want the monitoring frequency and reporting and certification requirements. There are many factors that affect the monitoring and reporting. The applicability of the categorical standards, the effluent and process variability, the flow or pollutant loading or both, and the type of pollutant. If you have nastier pollutants, you may want them monitored on a more frequent basis. And in the categorical regulations, you would want to review those and make sure that the monitoring is in accordance with the particular category. Most categories do not specify how many samples to take. However, there are instances like leather tanning where they have minimum monitoring requirements. Or in the non-ferrous metals manufacturing, there's a provision there where if cyanide is monitored and the first sample collected during the calendar year is less than 0.07 and the owner certifies in writing that no cyanide is used, that reporting is not required. The user should also be aware of how the discharger discharges. If it's a batch discharge, you'll want to have monitoring when that batch is actually occurring. Some POTWs require advance notice of infrequent batches so they can be sure to have the opportunity to monitor it during that time. A sampling location must coincide with the point at which the effluent limits apply, produce a representative sample, and must be safe, convenient, and accessible for the control authority to get in and conduct their samples. And the permit must clearly identify the designated sampling location. Often I'll see a drawing or sketch which has a box around where they're going to be sampling, or if it's an outdoor location, sometimes a satellite image with the manhole location indicated. Monitoring requirements. Pollutants to be monitored. They have to be clearly identified in the permit, and they're not limited to those in the effluent limits. Sometimes there's something that a control authority wants to learn more information on. Maybe there's a pollutant of concern that they don't have a local limit on currently that they want to see at what levels it's coming into their system. So they may require a monitoring only requirement. And if you have a mass limit, it's important that flow monitoring be required during the time that you're gathering information so that you could determine the mass limit. Sample collection method, grab composite, or flow or time proportional. And as we stated earlier, the reference to the analytical methods. The minimum monitoring frequencies must be at least once every 6 months for all SIUs unless the CIU has been classified as non-significant. The control authority has reduced the dischargers monitoring and reporting requirements under a middle tier classification, and that's only if it's allowed under your state law, or if the control authority has waived monitoring. And again, that's a streamlining provision that would have to be allowed under your state law. The next slide indicates the monitoring frequencies that are recommended by EPA for initial compliance. And this was based on using a 5 MGD plant. If your plant is smaller or larger, you may want to adjust these frequencies. These frequencies are listed as a recommendation and are not a requirement. The next slides, or I should say few slides, deal with the required reports and notifications. You'll note here that a number of the reporting requirements only apply to categorical users, while some apply to all SIUs. The baseline monitoring report, 90-day compliance report, those only apply to categorical users. But all significant industrial users, with few exceptions, have requirements for periodic compliance reports. There's also requirements for reporting slug loadings, or the requirement to notify the POTW if there's a discharge that has a potential to cause problems, so that the POTW can possibly make adjustments to their system to avert a problem with complying with their NPDES permit. Where a control authority collects all the information related to monitoring a facility, this includes the monitoring and the flow data, then a user would not have to report. However, where there's reporting requirements for a certification, like following a TOMP or a PMP, that's something that the control authority cannot monitor on the behalf, and those certifications still have to be submitted. Along with some of the notifications, there's notifications for a change in discharge, notification for hazardous waste, annual certifications for those that are non-significant, or I should say non-significant categorical SIUs. There you go. And notifications of bypasses or slug discharges. The reporting considerations should also be included in a permit. The permit should be signed by, or the permit reports, rather, should be signed by an authorized representative. The reports need to be sent to an address that's listed in the permit. The permit should list when the reports are due and how the reports can be submitted. Unless the control authority has gone through a review to have electronic reporting approved, the reports have to be submitted either by fax or by mail in hard copy and cannot be submitted as an electronic document. The review and approval for the cross-media electronic reporting regulation is granted only by EPA. That is not something that's delegated down to the states. and the requirements can be found in 40 CFR Part 3. Standard conditions can be included and should include the administrative and procedural things that are common to all of the industrial users. And once you develop a good boilerplate, that can be described in each of the permits. Some of the federally required components include statement of non-transferability, a statement of criminal and civil sanctions, national specific prohibitions, notification requirements, record keeping, and the process of seeking monitoring waivers if applicable. Special conditions for the users can include the requirement to control slug discharges. If a user is required to have a slug discharge control plan, that requirement should be specified in their permit, as well as changes that would affect the potential for a slug discharge. Special conditions can also be included in permits as well as compliance schedules. My preference is not to include compliance schedules in permits. Usually those are much better handled in a compliance document. Special conditions can include additional monitoring or temporary monitoring, as I discussed earlier. There can also be special conditions for zero discharge requirements or no discharge from a certain process. And those things can be spelled out for users that are basically dry or have their waste hauled off site.
Okay, thank you, Grace, for that informative presentation on permit components. Now let's see if our audience members can answer this quiz question. This is a multiple choice question. Which of the following is a federally required report or notification? A, periodic compliance reports from SIUs. B, periodic compliance reports from CIUs with pollutants not present. C, baseline monitoring reports from CIUs. D, notification of noncompliance. Or E, all of the above. While everyone's answering this question, I'd like to remind everyone that a certificate of participation will be available once you have watched 90 minutes of this webcast. Now the answer. Periodic compliance reports from SIUs, periodic compliance reports from CIUs with pollutants not present, baseline monitoring reports from CIUs, and notification of noncompliance are all federally required reports and notifications. Therefore, the correct answer is E. I want to thank everyone for answering these short questions. Now we're going to take some questions for Grace, but I want to note that we are running out of time to complete the webcast, so we're going to limit questions for Grace and the audience to just one question at this point, and then if we have time at the end of the webcast, we'll go back to your questions. So Annie, do we have any questions for Grace?
We do. So Grace, this first question came in. If I included everything in the permit that you mentioned, the permits will be over 20 pages long. Because specific prohibitions are established in my sewer use ordinance, can I just reference the appropriate sewer use ordinance citation and not rewrite the entire clause in the permit?
That's a good question. I get that question a lot. The preferred method for is to include all the required components, which would include the specific prohibitions. I know it makes a permit pretty lengthy, but it's better to include that so that they know what their requirements are. If you do decide to reference it, I would recommend that you attach the applicable sections of your ordinance to the permit so that the user is well aware of what their responsibilities are as far as compliance.
Okay, thanks, Grace, for taking that question. I believe Jan's going to wrap up today's webcast by discussing documentation of permit decisions and administrative records. Jan?
Thanks, Grace, and thanks, Chuck. I know you'll agree that the mantra is repeated frequently in the pretreatment program, document, document, document. And I know both Chuck and Grace will also agree that we often say the statement, if it isn't written down, it didn't happen. So you might want to remember those phrases. We say them a lot. When a control authority is setting up its pretreatment program, one thing that is guaranteed is that the reports will have files, and there you'll have records and records, and you're wondering what all needs to be kept. We're going to discuss this in a very vague manner, but one thing to remember is that some records do need to be retained for 3 years, and then when you're specifically talking about a permit file, you really should be keeping the permit file at least for the permit duration. If that's up to 5 years, yes, keep that 5 years and then keep it for that 3 years beyond that. And, of course, if there's any court case, you've got to keep it until that court case is completed. Now, when we're talking about administrative records that a control authority is going to have, you need to basically view any of the records you develop or receive as part of your pretreatment program to be part of that administrative record. Everything that includes stuff you collected for writing the permit, reports that you received from the industry about their wastewater, analytical reports that the control authority developed for sampling of the wastewater, inspection files, files that include the violation notices. It does include a lot of things, even down to correspondence. Now, specifically when we talk about permit development, we're talking about having a permit record that includes all of that information used for writing the permit. You might have a permit application form that your community uses. For a categorical industrial user, you're going to have a BMR. When you write your permit, not only do you have the draft permit you developed that you might have allowed public comment, and then your records that include all those comments you received, but also your fact sheet, which we strongly recommend be developed, that explains the basis for all those conditions in the permit. You need to include information about the public hearings and meetings, because that demonstrates that you, as the control authority, have satisfied that administrative process that is required by your state and local government. Keep that as part of the record, too. Hey, here's that phrase, document, document, document. Here are some key items that go into that decision-making process about writing that permit. It's important to keep track of why a facility has limits. It does. Why that? Because that facility might add a process tomorrow, and you might be tasked to modify the permit to address that expansion. So you need to know why you have the conditions in that permit today, and so you know exactly what you're changing. This includes everything for how you did permit calculations, when you're taking that limit, multiplying it by the flow to come up with the mass, all of that stuff. And remember, a permit only lasts a maximum of 5 years, and then you need to decide what conditions are included in the next permit. Now, I did say a few seconds ago that EPA strongly recommends keeping a fact sheet that explains the basis for the decisions you made when you included conditions in the permit. We basically call that fact sheets. It describes all of the legal procedures you did, as well as the policy issues you used to put those conditions into the permit. However, because permit fact sheets are not a binding part of the permit, the permittee requirements must be explicitly put in the permit in order for the requirement to be enforceable. The permit fact sheet just explains the things in more detail, like all of the math written out to show that you multiplied this by that, you divided this by that, so you can check your math and somebody else can check your math for you. You would also include such things as the descriptions of the industrial process and why you might have called that categorical industry that particular categorical industry, and why you then imposed those standards onto that industrial discharger's wastewater. And so, when you think about that, your permitting process also includes correspondence. You have to keep all of these things in your file, too, as part of the administrative record, because it's a matter of when did you learn what, and make that file be the history for you. Then you don't have to rely on your memory, but you can rely on your computer's memory or your paper records memory. Remember that the information gathered for permit writing and demonstrating that the industries and POTW are complying with the Clean Water Act are requirements for the pretreatment program are all part of the permitting record. Consequently, the public needs to have access to this information if it wants to see anything of it. The control authority might set up office hours in a library or even import data onto the internet to allow viewers to access the data. One last reminder, as I mentioned public access to data, is that information used to develop permit limits or is submitted to demonstrate compliance with permit limits cannot be considered confidential business information. Along with the control authority determining how it will make the data available to the public, the control authority needs to be prepared to evaluate something it receives that the industry claims to be confidential. It needs to know what that definition of confidential means, if that information actually qualifies to be classified as such, and then be able to act accordingly.
Okay, thank you, Jan. It looks like we've got a few minutes left to answer additional questions from the audience. But first, I want to remind you that this presentation will be archived so you can access it after today's live presentation. The archived webcast will be posted in a couple of weeks on EPA's NPDES website. Ishi and Annie, do we have any questions for our speakers?
Chuck, we have some questions for Jan. Jan, POTW wants to know if the control authority consider all of its IUs as significant.
Well, the definition of significant, to just briefly remind you of what that is by default, all of those industries that are subject to categorical pretreatment standards, unless the control authority has other classifications of categorical pretreatment standards. But significant also includes those industries that discharge an average greater than 25,000 gallons per day or more of process flow, contributes a process waste stream that makes up 5% or more of the average dry weather hydraulic or organic capacity of the POTW treatment plant, or is designated as such by the control authority on the basis that the industrial user has a reasonable potential for adversely affecting the POTW's operation or violating any pretreatment standard or requirement. So yes, if that POTW declares that all of its industrial users have reasonable potential for adversely affecting the POTW's operation or violating any pretreatment standard, they could include it under that last clause.
Great. Thank you, Jan. I hope that answered your question. Here is another one about permit transferability. POTW wants to know if there is an existing permitted SIU, and if that SIU moves to another location, yet they're still going to do the same process, can that existing permit be transferred to the new location? Jan?
Well, there's several things in that question. If they move to a different city, that industry really needs to contact that other municipality because they may be subject to a different control authority's legal requirements that has different standards to begin with. If we're talking even the same industry moving across town, it no longer, if it was a categorical industry, it might be subject to a different set of standards just because it moved into a new facility. There's kind kind of a lot of things embedded into that question that's beyond the scope of this webinar, but that probably is something that might be addressed by the December webinar, so just hold tight and talk more about the situation then.
Okay, thanks, Jan, for taking that question. Finally, we want to ask the audience to complete the survey that will be appearing on your screen. Please consider completing the survey and let us know your thoughts on this webcast. We do appreciate your feedback as we want to improve all of our webcasts. I think we've got time for one more question. Annie, do you have a question for Grace?
I do. So, Grace, this one came in. As a control authority, I have performed a slug discharge evaluation at a permitted SIU. I have determined that the SIU is required to develop and implement a slug discharge control plan. So does the slug plan drafted by the SIU need to be incorporated into the permit?
The answer to that question is no. The actual terms of a slug plan do not need to be incorporated into the permit. EPA expects you to include language in the permit that requires the control of slug discharges rather than the terms of a particular slug discharge control plan. But if there's requirements to develop a plan or requirements for retention of information that shows implementation of that plan, that particular information could be required in the permit. Now, I would recommend that a plan be incorporated by reference into a permit, but it's not a federal requirement.
Great. Thank you, Grace. A couple more questions before we wrap up, and I turn this back to Chuck. Jan, we got this question from the audience. Can the control authority issue permits to non-SIUs?
Okay, this is directly something I did cover. Yay. So somebody wasn't really listening, or they want it to be repeated for them because they want to nail that answer. Yes, if you remember back when I talked about legal authority, a POTW is required to have the legal authority to be able to control through permit, order, or similar means the contribution to the POTW by all industrial users. That's a quote directly from 40 CFR 403.8F1 little 3. So yes, it needs to be able to have the authority to be able to issue permits to all industrial users, SIUs and not SIUs, but then it prioritizes which of those users it starts in its permitting program. Really depends on what's all affecting the POTW and where to start. But remember, SIUs are required to be issued the permits, but they got to have that full legal authority. Because one of those IUs might cause a problem with that pretreatment plant or in that collection system, and then you know what? Bingo. They turn into an SIU right then.
Okay, thanks, Jan. We want to thank the audience for all your questions. And a reminder, if your questions were not answered during the webcast, we've posted the speaker's contact information in case you'd like to contact them after today. You can also find a copy of the slides by clicking the Downloads button on the top of the screen. A certificate is also available for each participant by clicking on the Certificate button at the top of your screen. The certificate is also available by typing the link into the slide into your web browser. You can type each of the attendees' names into the link and print the certificate from your computers using this link. If you are having trouble using the button here on the slide, we recommend that you use the link, and it's supplied here on this slide. Okay. Well, it looks like this is at the end of all the time that we have. So at this time, we'll conclude today's webcast. We want to thank our two speakers, Jan and Grace, and of course, we want to thank everyone who attended. Please note that the next pretreatment webcast, POTW Pretreatment Considerations and Permitting Programs for Hauled Waste, is scheduled for Wednesday, October 24th, 2012. This webcast will focus on POTW considerations prior to accepting hauled waste and how to develop a permitting program for this type of waste. The registration for this webcast will be open soon. Information regarding upcoming pretreatment webcasts can be found by clicking on Trainings and Meetings at www.epa.gov/NPDES. Once again, thank you everyone for participating in today's webcast. This ends our Pretreatment 101 webcast on industrial user permitting.